Appeals of Tennessee is in session.
Good morning and welcome to the morning session of the Court of Appeals. Your panel this morning will be Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. Each side will have 15 minutes to present their case. The appellant can reserve as much as 5 minutes for rebuttal. Has the appellant reserved time?
Yes, sir.
All right. All right, you may call the case.
Eman Alkhateeb versus Ahmad Al-Wiri.
Ms. Alkhateeb, you can present your case now.
Good morning, Your Honors. May I please the court? My name is Eman Alkhateeb. I am the appellant and I'm also the mother in this case. There are 4 main issues related to the minor's minimum basic needs, which I would like to discuss with the court today. I will speak of logic and reason with evidence from records to prove how the appellees' frauds and violations caused extreme unfairness in court's decisions. The first issue, the court erred in awarding the unfit father shared custody in the permanent parenting plan. It also erred in not taking any judgment against his 14 consecutive willful months willful violations and the abusement of the children caused by him and his girlfriend in the temporary parenting plan. The court should not have adopted their permanent plan for 2 reasons. First, the court did not take into account evidences of 7 police reports and text messages submitted in the hearing proved the appellee's willful violations. He did not exercise his parenting time or any of his parental rights for 14 consecutive months. According to Tennessee law, abandoning a child is 4 consecutive months without visiting or paying support. Evidence in the record, page 68 to 88 in the supplement record. The second reason, since court's order on temporary parenting plan in May 2019, the appellee exercised his parenting time only 42 hours and only 2 weekends. That's when he and his girlfriend, Brisa Dilao, who he admitted adultery with, abused the minors. They got reported to the Department of Children's Services, who investigated and referred the little girl to Health Connect. Evidence, page 89 in the supplement record. I would like to point out that their only reason for not settling the case was the appellee wanted to exercise his parenting time in days different than those in the temporary plan. So the court adopted their plan with the exact days they requested and entered that as a permanent plan. The court also added to the plan their agreements in the hearing on renewing minors' passports and allowing them to travel with the mother. The result, the violating appellee still never exercised his parenting time or any of his parental rights, and he's still refusing to sign the traveling agreement. After the final divorce, he traveled 4 times to Jordan, but preventing minors from visiting their sick grandparents or traveling anywhere since they came to the state in 2015. As you can see, Your Honors, the appellee not only waived his rights to exercise his paternity, but also he abused parental authority given to him by court. The court decision should be reversed. According to Tennessee child custody law, decision authority is related to the amount of time the parent spent with the child. Therefore, the mother, who is the sole caregiver since 2017, should have sole decision-making authority over the children. Also, the traveling agreement is an urgent issue, should be enforced through the court as soon as possible, and the abusement should be sent to juvenile court for judgment. The second issue, the court erred in using the appellee's fraudulent affidavit of income and expenses as a base to calculate and determine the permanent and the modified temporary child support and alimony. The court should not have accepted this affidavit for two reasons. The first reason, they were violated court order by not submitting document regarding his bank accounts and his AB Latino business. He claimed work there for 1,600 monthly. As a matter of fact, four motions filed and granted request the disobedient appellee to submit documents regarding his assets, vehicles, bank accounts, and tax papers, businesses, but he and his attorneys, they never submitted those documents through the whole entire divorce. We can see this in page 75, page 132 in the record volume 1, in page 52 and 53 in the supplement record, we see the fourth motion filed on March 2020. The second reason, he claimed in his expenses 1,484 monthly payment for the trustee. A copy of his bankruptcy application submitted in the hearing proved his fraud. He voluntarily filed bankruptcy case with fraudulent personal and asset information. The children who used to claim in his tax return from 2013 to 2018, he denied having them. Evidence, page 66 in the supplement record. I would like to point out that he voluntarily dismissed the bankruptcy case after almost 2 months and a half after the final divorce. Because of his frauds, we live with total amount of 350 of child support and alimony. He wasn't, not only that, he wasn't paying child support for 8 consecutive months, and he's still not paying alimony for 8 consecutive months. The court decision should be reversed. The child support should be recalculated in juvenile court retroactively. The third issue I have, the court erred in not awarding the sole caregiver a vehicle. The appellee's frauds and violations prevented the mother from using a vehicle during the divorce and getting a vehicle after the divorce. First, the appellee prevented the mother usage of the 2017 Chevy Tahoe by submitted fraudulent bill of sale for that vehicle. On mother's motion, emergency motion for exclusive use of a vehicle, which was filed in February 23, 2018, the day after the mother got arrested, because the appellee provided her use of uninsured car that was reported stolen by the rental company because he did not pay for the renewals. When in the meantime, he was driving 2016 Chevy Camaro and let the girlfriend drive 2017 Chevy Tahoe. In the final hearing, after mother submitted proof of his ownership of the 2017 Chevy Tahoe, which is in page 99 in the supplement record, the appellee in the final hearing, he admitted his ownership of the 2017 Chevy Tahoe, that he was claimed before that he sold, and he submitted fraudulent bill of sale for that. We can see this in the evidence. The evidence is page 146 in the record volume 2. So we can see he admitted a fraud and prevented the mother using the 2017 Chevy Tahoe. If we look at page 96, the bill of sale in the supplement record, and page 24 in the record volume 1 in the mother's motion, and page 99, the proof of his ownership of the Tahoe, we can see the same VIN number for the 2017 Chevy Tahoe. In the final hearing, the mother proved his fraud in his affidavit of assets. He claimed having one vehicle. The mother submitted evidence show the appellee ownership of 2016 GMC and other four used cars. We can see in the supplement record, page 101 to 107. And on page 112, in the supplement record, we can see his affidavit of asset where he claimed he owned one car. So the court's decision was extremely unfair. The mother, who is the sole caregiver, rely on Uber, friends and family members since February 22, 2018. The fourth issue. The court erred in awarding the sole caregiver the modified alimony of $790 as a transitional alimony for 12 months. First, the amount of the alimony the court calculated was incorrect because it was based on the appellee fraudulent affidavit of income and expenses, which I proved the fraud in the child support issue. Second, the court applied alimony determination factors incorrectly. The court did not take into account the evidence submitted in the hearing, which show the appellee ownership of the marital home. The appellee transferred his ownership of the marital home and another 2 houses for his cousin. And then that cousin, he transferred the 3 houses to another cousin. And that proved his fraud when he claimed in the hearing that he has signed a lease with his cousin. And then after that, he and his cousin evicted us from the marital home in the pandemic. And that was on July 14, 2020. After suffering major house repairs affected minors' health and safety. We could have ended up homeless without church and Muslim community help. Also, the court did not take into account evidence proved the mother is the sole caregiver and the mother contribution made to the appellee earning ability, the mother giving him citizenship, and she was staying home, taking care of the children, and the appellee marital misconduct, which he admitted adultery with his girlfriend. So the decision should be reversed and the mother should be awarded a sufficient permanent alimony. This is the 4 issues, I would like to discuss with the court today. And I think time is almost over. Thank you for listening, and I reserve 2 minutes for the rebuttal.
All right, thank you. Excuse me, before we start, I've got my full screen is showing the clock rather than the parties. Is everyone else seeing that?
I actually don't see anyone. I just saw the.
I'm talking to our technical people.
Yeah, I ended up doing that because Miss Alkhateeb wasn't able to see the clock because of her being on a phone, so she wasn't able to do gallery. So I spotlighted it just so she was able to see it, but I can turn that off. I
see. Yeah, I'd rather see the party if I can. Oh, the council.
Yes. Yes, we can do that. Hold on. No. There. All right, it should be able to see everybody now.
I say. I will hear from the appellate. I've got Kevin's name on my screen now.
Try changing it back to gallery view.
A minute. All right. I think that's different than what I'm used to, but I can see everybody now at least.
Okay. That might have rearranged everything, but yeah.
All right.
I can't. Okay, right now.
It should be 15 minutes, shouldn't it?
I reserve 2 minutes.
Yeah. Kevin, Nick, this clock is showing 13 minutes. Okay. All right, we'll hear from the appellee.
Good afternoon, Your Honors, and may it please the court. My name is Adrian Vivar, and I, along with Stuart Breakstone, represent the appellee, Ahmad Al-Awari. For purposes of clarifying a bit of Ms. Alkhateeb's argument, this was a marriage that began in 2009, and the parties were finally declared divorced in November of 2020 after nearly 3 years of litigation. A portion of this divorce was extended due to ongoing disputes on Mr. Al-Awari's ability to exercise parenting time, as well as Ms. Alkhateeb's contention that he had not been paying temporary support. In total, contrary to Ms. Alkhateeb's oral argument, she has received alimony and child support since February of 2018. Mr. Al-Awari's alimony actually terminated just this December. In response to her brief and oral argument, there's a couple issues that this court faces in deciding whether Ms. Alkhateeb proved her burden in showing that the trial court erred in its decisions.
Let me ask you a question. Is there a transcript of the evidence in this case, or is it a statement of the evidence? Or we just rely on the court's order?
There is not, Your Honor. There is neither a statement nor a transcript. We're solely relying on the technical record.
All right, go ahead.
I contend and submit to Your Honors that the references that Ms. Alkhateeb has made throughout her oral argument, as well as her brief, to this supplemental record are documents that this court cannot rely on in making its decision. Rule 13 of the Rules of Appellate Procedure clearly provide a procedure on how these documents are to be submitted if a transcript or statement of evidence is not submitted through the clerk's office. Further, I can't, from a review of the records that have been submitted by Ms. Alkhateeb, I cannot confirm whether these documents were ones that were submitted to the court at the trial level to consider.
How are the documents? Where are these documents? Are they in the record?
They're not. They were submitted as part of Ms. Alkhateeb's initial brief, but they are not part of the record.
All right. All right.
And which returns to my contention that these should not be considered under Rule 13.
All right.
Further, Your Honors, I submit that the briefs that Ms. Alkhateeb has submitted is so deficient under the rules of procedure that her argument should be considered waived at this point. Chiozza versus Chiozza is a nearly analogous case decided by this court in 2009, where the deficiencies in the appellant's brief were so substantial that it did not allow this court to adequately review the record and decide how the trial court erred in making its decision. There's no references in Ms. Alkhateeb's brief to what documents were presented to the court to consider and how exactly the court relied on a fraudulent document beyond the fact that Ms. Alkhateeb disagreed with its contents. Concerning the record, if this court disagrees that the deficiencies in Ms. Alkhateeb's briefs are not substantial enough to dismiss it on the merits, I submit to Your Honors that it's the deficiencies in the record do not allow this court to consider the evidence that she is contending should be considered outside of the record submitted by the clerk's office. Rule 24 governs how partial exhibits and transcripts can be submitted. There is no transcript, there is no exhibits, so this court can only rely on the facts that the trial court has concluded. The case law is clear that a trial court's findings of facts are conclusively presumed to be supported by the evidence where no transcript and no statement of facts have been submitted by the appellant. This is exactly the case here. The trial court noted in its final order that there were credibility issues by both parties at the time of trial. Despite that, it weighed the evidence presented at the time of trial to conclude that the parenting plan submitted by a husband was in the children's best interest and should continue moving forward. Ms. Alkhateeb's contention that Mr. Alawari's parenting time should essentially be terminated is not the proper procedure for this court to consider. This is something that should have been submitted at the trial court level or in juvenile court. This is not an issue for the court, for a error correcting court to consider. This is, if she disagrees with the trial court to the extent that she thinks the parenting plan should be modified, then she has avenues to do so. But simply put, this court is not that avenue. Lastly, Your Honors, I would submit that in a review of Ms. Alkhateeb's brief and her oral argument here today, she continues to rely on events that have occurred since the final order in this case. That, as Your Honors know, that is not something for this court to consider. If she has issues with the way parenting time has gone, and I'm not here to admit or deny whether that has occurred, but if she disagrees with the trial court to the extent she believes the parenting plan should be modified, she has avenues to do that. But this court is not that avenue. With that being said, I unless Your Honors have any other questions for me, I yield the remainder of my time.
Any questions?
Yeah.
All right. We'll hear from the appellant. Ms. Alkhateeb, you have 2 minutes in rebuttal.
Yes, Your Honor. Actually, the appellee and his attorneys, they were failed to comply with Tennessee Rules of Civil Procedures, Rule 33.01, interrogatory, and Rule 34.02, request for production of documents. Because of they refused to submit documents, and as I proved, and I said this in my brief, the record did not have enough. This is why, the court decisions was unfair, because they didn't have enough evidence. They deceived the court, defining his violations and his frauds. They play a major role in preventing justice. They did not provide evidences to refute my evidences, and I still challenge them to do so. They were saying there's no transcript, but I ordered transcript and records. But the transcript, as I informed by circuit court, they cost thousands, and I was not able to submit the transcript. And all the evidence I submitted, they were submitted in the hearing. So those evidences are from the hearing. They couldn't say those evidences are not right because they were submitted in the hearing. The appellee, he admitted marital and economic misconduct 3 times in the trial. First time he admitted adultery with his girlfriend, and that was in the record in page 146. Second time he admitted purchasing 2017 Chevy Tahoe for his girlfriend. And that was on September 2017, which was before the divorce. And that's also in the record in 146, in page 146. The third time he admitted on his answers on January 2020 that in his response to interrogatories that he took his girlfriend to Florida and Atlanta to celebrate her birthday. And that was in November 2017, before the divorce. So as you can see,
Ma'am, your time on rebuttal has concluded.
yeah, the last thing I want to say that this is the country of justice, and I believe in the justice of this honorable court. Thank you so much.
Ma'am. Thank you, and we'll take this matter under advisement and render you a written opinion as soon as possible. Thank you both very much for your argument.
Thank you.
Thank
This
you.
honorable court is in recess until 1 p.m.